with utmost urgency for any necessary amendment, formulation, enactment of the statute law to give effect to this judgment on the mandatory nature of the death sentence and the parameters which ought to constitute the imprisonment. Those are three problems which is awaiting your resolution. How do you intend to solve them?
Yes, thank you, Myron. Thankfully, I've written an essay on the Muruatetu case, and it's part of my sample writing that I shared with the Honorable Commission, which shows that I'm acutely aware of, I would call operational problems that arose from that decision that affect the criminal justice system, and they need to be fixed. The judgment was profound. It was groundbreaking. In one pronouncement, that sentencing is judicial authority to determine the proportionate sentence is the discretion of the magistrate. However, death penalty is still a provision in our law, and it still remains. But death penalty as the only penalty is unconstitutional because it takes away the role of the judicial officer to determine the appropriate sentence to give. And the reasons are very well stated in that judgment, and we all agree with them that not all murders are the same. Some of them are grisly. Others are somewhere there. They are not manslaughter, but really you can see the violence that was met. Or the best example is robbery with violence. Not all robbery with violence are the same. Walking down here, some youth, 3 of them would like to grab my chain. They threatened me with a stone or something to beat me, and then they ran away with my chain. That's robbery with violence. And there are other robbery with violence where people come with guns, terrorize a family, rape, cause mayhem. That's also another robbery with violence. So when it comes to sentencing, before the magistrate would say, my hands are tied. This is a simple robbery, but it attracts death penalty because the ingredients of robbery with violence are present. The perpetrators were more than one. They were armed with a dangerous weapon. Never mind, it was something not really that can inflict. It's a knife, but they never even used it. But the victim felt threatened, and they robbed. So in that sense, it helped the justice, so that judges, magistrates can mete out proportionate judgments according to the circumstances of the case. Now, that judgment opened a Pandora's box by saying all those people who are sentenced to death apply for review, and also directed the Honorable Attorney General to come up with a policy and eventually the Speaker to amend the laws. This is our country. These are our problems. We have to solve them when they occur. So for me, immediately what I can do is follow up with the Attorney General to see whether that sector-wide report on sentencing has been prepared, to inform also our sentencing policy, so that our sentencing policy now takes into account the recommendations from the Supreme Court, so that but having worked with the Muruatetu in the Court of Appeal, we have also held this view, and I believe you are one of them, including my lady, the Acting Chief Justice, that this matter perhaps needed to be mentioned in the Supreme Court for certain clarifications. For instance, you mentioned a life sentence. What is life sentence? Is it 20 years? Is it 15 years? I think the Supreme Court would do well to define for us what do we perceive to be a life sentence. I think in the Court of Appeal, the trend is anything 20 years is a life sentence. But we need a coherent, coordinated approach to sentencing, and that is actually what is contained in my paper, which I prepared following a request from the President of the Court of Appeal. We had a whole week dealing with the matters where accused persons were sentenced to death, and they filed their appeals in the Court of Appeal, and then they have gone to the magistrate court where they were tried, and they have sent revision, and their sentences have been revised. When that sentence was already affirmed by the High Court, and there is a pending appeal in the Court of Appeal. So we go to do appeals, they are called, and we were told they were released. You know, that looks like a backdoor release, because once the sentence was affirmed by the High Court, there is no way you can go back to the magistrate court. So there is a lot of instability in the criminal justice system. So when I'm Chief Justice, we can look at the Muruateto case again and core parties to mention and discuss those issues and see whether clarification can be given, because this is the apex court that should give directions to the other courts. And then the law reform, of course, should be involved, the AG and the public stakeholders, because this is a matter on criminal justice. And also we review our sentencing policy. Thank you.
So you will agree with the school of thought that says the Muruateto has created unpredictable, disruptive interference of courts against sentences lawfully provided and lawfully imposed.
Thank you, my lord, but I don't think I would use those strong terms, because I have already discussed how helpful it has been in helping the judges to determine a proportionate sentence to give. But there are other problems. It needed to be monitored. This is actually one judgment that needed to be brought for mention again before the Supreme Court within 3 months, so that the problems that were arising out of it, because this was a murder case. This was death penalty as provided for a murder offense. But through parity of reasoning, and you can't stop judges from exercising their minds to compare situations. It has been used for robbery with violence. It's been used for sexual offenses. Really, we are at a bad place in the criminal justice.
So, in your just one of your sentence, you said sentence a judicial authority, and the judge or the magistrate should impose the appropriate sentence. In the circumstances of what the law provides in terms of minimum and maximum sentence, in all our statutes, both in the Sexual Offences Act, both in the Narcotic Act, both in the Anti-Corruption Act, and many acts, they provide for maximum sentences, maximum and minimum sentence. What is your view? Does Muruateto apply to Sexual Offences Act?
My lord, as you know, we sit within the Court of Appeal. We know it has been applied in sexual offences, and there are situations where I've agreed that it comes in handy to determine the proportionate sentence, especially where it's a case where there was no violence, there was consensual sex between the victim, and their age difference is not huge. Let's say the boy is 19, because we don't have a youth justice here in Kenya, and we need a youth justice. You cannot graduate from being a child at 18 And when you're just 19 and 20, you are dealt with strange hammer of the law. We need to nurture our youth. That is a failure of our system in the society. So in these cases where there was no violence, it's a Romeo and Juliet case. The age difference between the victim and the perpetrator is not huge. They were girlfriend, boyfriend. I've seen the Court of Appeal reduce the sentence to, say 5 years, or, depending on the circumstances of the case, a slap on the wrist on the perpetrator.
Okay. Now that we are discussing the Muriotetu case, I just want to finalize. Do you think the problem is the High Court, Magistrate Court, and the Court of Appeal interpreting the judgment of the Supreme Court? Or is the problem the Supreme Court? Again, 3 years down the line, the Honorable Attorney General, the DPP, and both speakers have done nothing in terms of implementing the judgment. So where do you think is the problem?
Thank you, my lord. I think the problem is all of us, the society, and we have to depart from, I think the Constitution requires us to stick to the values of consultation, participation, negotiations, reaching out. So we need to reach out, because I think the buck stops at us as the court. Is the court that is being projected as the one which is not functioning, or which is not coherent in the way we are doing our things. So we need to take it up. And when I'm Chief Justice, I think the first thing I would do is issue a practice direction on how Muriotetu should be applied. And I think, I believe my paper, which I've shared, has some policy recommendations.
Thank you, my lady. The second issue which I see a problem, which you need to solve, is the debate about substantive and procedural justice. One of the issues which you need to resolve is the issue that has confronted the Court of Appeal and also in the Supreme Court about where to file the notice of appeal in election matters. And I have a particular case here, the case of Musa Sirma, where the notice of appeal was filed at Kaparnet, where the trial took place. But the judges took the view, the Court of Appeal judges took the view that this was not filed at the appropriate registry. The Supreme Court, addressing its mind, also agreed with us. What is your view on that debate? Because I know even us in the Court of Appeal we are divided on that issue.
Yes, thank you very much. I think the Constitution gives us the command that we should always aim at doing substantive justice as opposed to looking into the procedure. But we all know that the procedure is the one that feeds the substance. And the procedure is the one that brings predictability, because I know if I have this kind of a problem, I will follow this procedure, and then eventually it will lead to substantive justice. And I belong to this school that asked, was the notice of appeal filed? Was it filed timeously? And I would overlook the fact that it was filed in Kabarnet Court as opposed to Nakuru or whichever the High Court that was hearing the petition. So like you say, this is a divided opinion, but since we are reviewing our positions before the next elections, these are matters which will be discussed by judges, and they come up with one common ground. on the way to move forward in future, because perhaps it was not a mistake that they found in cabinet. If that is where the case was handled originally, they probably overlooked the provisions of the law. We always say that ignorance of the law is never a defense, but we encounter these problems every day. Depending on the circumstances, we allow when we are looking at the bigger picture, which is justice.
Thank you very much. And lastly for me, my lady, I don't want you to comment on the merit of the case, but what you will do as a Chief Justice of the Republic of Kenya. The recent case of the BBI, where the Supreme Court, where the several cases were filed in the High Court and other cases were filed in the Supreme Court, I think by December or November, something like that, and the case was mentioned several times, but lastly there was a ruling delivered by the court on the 16th day of March 2021 saying let the matters in the High Court be resolved. There is a school of thought that says since the Supreme Court confirmed that this was a matter of great public importance, the High Court does not have jurisdiction, and it is only the Supreme Court that has jurisdiction, and that it was not right for them to refer the matter or to stay the matter pending the resolution of the High Court matters. What will you do? Because this is the apex court, and it must lead in terms of jurisprudence, and it must lead in terms of issues affecting the country. What will you do if you are the Chief Justice?
Thank you, my Lord. Those are very turbulent, sensitive matters because they are live. I cannot really discuss them because they are sub judice. But since you have cautioned me not to go to the merits of the case, I'll just tell you what I can do. If these are matters of general public importance that affect a close section of Kenyans, I will read those files. We will call a conference of judges of the Supreme Court and discuss and see the way forward, and then move from there. Whether the Supreme Court takes over all the matters that are pending in all the courts and hears the matter, that will be, a discussion arrived at from a participatory and consultative forum of the judges of the Supreme Court.
Sorry, this is my final question. Final question. I'm sorry. And I just forgot to ask a question that has been given to me by the Commission. How will you resolve the dilemma of the 41 judges? And this is a standard question for all candidates.
Thank you very much. This one must be resolved. Like I said, through negotiations. There is one major problem I see with perception of what is judicial independence and what is interdependence. Because we are independent. The judiciary independence is secured in the Constitution. And nobody can claim to take it, and nobody should attempt to take it because it will be unconstitutional. But the judiciary is accountable. They go hand in hand. And the judiciary is interdependent because we all serve Kenyans. The executive serves Kenyans. The legislature serves Kenyans. Therefore, when the right hand doesn't know what the left hand is doing, or is not agreeing with what the left hand is doing, the body, which is now the Kenyans, are suffering because of the standoff. So when I was preparing for this interview, I know of the National Council on the Administration of Justice that brings all the actors together to discuss coordination of the administration of justice. I've also read the Intergovernmental Coordination Act that makes provisions on how the central government relates with the county governments. And there is a whole act of parliament complete with the mechanisms of how to deal with stalemates and standoffs. When I looked at the judiciary, we are interdependent as far as the delivery of service is concerned, and that's our core business, delivery of service to Kenyans. We get our money from the consolidated fund. We are part of the government. So we need to explain what is interdependence. Where do we come together on matters of administration of justice? The human resource, the capital, the budgets of the judiciary, the infrastructure, all those are projects that involve everybody. So we need an act of parliament operationalizing the NCAJ, and therein a mechanism for resolving any standoffs. Regular meetings with the executive, with the legislature, so that when the CJ is seen with His Excellency the President, people do not think that they are discussing a case, because our independence is in decision making and in hiring. The other things, we are interdependent. When the CJ is seen with the President, they are discussing matters on administration of justice, that everybody is responsible. It's not a beauty contest who serves Kenya better. Is it the executive, the judiciary? We are all in it. So if the judiciary is failing, the economy is failing because disputes are not being resolved. The President gets affected and everybody gets affected. So we must discuss this issue of 41 with the President in that atmosphere of we are serving Kenyans, all of us, and we are concerned about the administration of justice. And we find out where the problem is, resolve it, and get the judges in office.
Thank you very much, Judge, and I wish you well.
Thank you.
Thank you.
Thank you very much, Judge Koome. Honorable Commissioners, I would want us to take a 5 minutes break. I think we need to fix the lines so we are all together. So, Judge, you can take some water, a health break of 5 minutes. We come back 11:05. Thank you very much.